the Seaward Room
Thanks, mate.
over in Perth. So we started the recording. Now, I am getting Scott Gilbert. I think you need to go on mute, mate. Thank you. All right, very good. Thanks, guys. So I'll start like I want to do with a joke. And given that this is being recorded, I'm going to try really hard not to use any swear words or any inappropriate material a lot. But as Jason Oster and Nick Bell will know, that's a real challenge for me. So we'll give it a go. All right. So there's a conspiracy theorist, well-known conspiracy theorist. He dies and goes and he finds himself at the pearly gates in heaven, and he's met by St. Peter, and St. Peter says, "Look, you go in here. We've got the angels here. Look, if you don't behave, you can still be cast out. You can go into hell. That's below. We've got purgatory over there for people who haven't got decided yet, but you've got through." You can make it into heaven, got a few concerns, but no, we can make it. But just before you come in, a new missions policy up here, you're allowed to ask God one question, and I'll go and get God's answer, and then if you're happy with that, you can come on in. And the conspiracy theorist says, okay, all right. So can you ask God who killed JFK? And so St. Peter says, yeah, no problem. So he goes in. Comes back out and says, God says it was Lee Harvey Oswald acting alone. The conspiracy theorist thinks for a moment and goes, this goes deeper than I thought. All right, that one didn't work. Okay, so let's go into the risk management, the risk management module 2025. Now, I have been acting for valuers since 1992, and what was notable about starting litigation practice in 1992 was that we'd just come off a real fall in property values in the first quarter of 1989. There's very little corporate memory around about the impact that had, but litigation lawyers and insurance litigation lawyers like myself were kept extremely busy doing valuers claims up until about 1999-2000. And to put that in context, I myself would do about 30 a year. And within Phillips Fox, who was doing that work, we were really doing about 80 to 100 a year just in our own firm for the best part of that decade. Now you've got to compare that to where we are now, which was that there was not one claim made against a valuer for the years of 2021 and 2022. So not one. So that's been a dramatic change. And the main reason for the dramatic change is, well, firstly, we haven't had a fall in property values right across the board like we had in 1989 ever again. The financial crisis in 2008 was a real blip on the radar. We've had a very strong economy, and I think with this data-rich world that they're in, things move a hell of a lot faster and the property market tends to recover. On top of that, we've had a huge consolidation in valuation firms. So compare that to the early 1990s, where someone like Commonwealth Bank would probably have 70 or 80 firms on its panel just to do residential. When we had the CBRE acquire McGaw and Hogg in 2005, and that started the huge consolidation of law firms. Valuation firms, where you've really now got, about 5 brands, including your own, that is doing, 80 to 90% of the certainly the residential mortgage work in Australia. And that's brought with it, more negotiating clout at the table, but also a real consolidation of professionalism and skills. And there's been a few people that I think, have really changed that. Certainly within your own firm, I won't necessarily shout them out, but they've been, tremendous advocates of proper professionalism and getting the job done in the right way, which has all but eliminated risk certainly in the residential mortgage sector. So I'm not here today to talk about how you do a property pro valuation. I'm not here to talk about the supporting memorandum or how you get that stuff done right. I am familiar with those documents. I drafted large parts of the supporting memorandum in conjunction with the major banks. Jesus, that'd be 15 years ago now, and was actively involved in that process. So I'm more than happy to answer any questions that anyone's got about that. But this is all about looking at the fundamentals of what you guys need to know and sticking to it. And the main reason I'm talking about the 1990s is that there are behaviours that are going back to the 1990s amongst your client group. I'm starting to see it a little bit more in relation to valuers that are going back to, you know, a few making lots of assumptions and really aggressively doing property values, you know, in a way that they know really can't be justified, but they think they'll be able to get away with it because there's a section of the market that wants that kind of advice. And this is just to emphasise to everyone on this call as to really a reminder as to what proper professional practice is, and where the pitfalls are going to lie, and how you've just got to stick to being proper professional people, and really embrace and really value that. So that'll be part of it. Certainly happy to take any questions, but I also want to talk, you know, just for a brief time about your business at Knight Frank. One of the benefits and challenges that you have as a franchise organisation is that you're now not, you know, centrally owned, and in the residential sector, you're now up against HTW, who've recently done a deal with a private equity provider called Quantum PE. Optian is pretty much corporatised and is now really the one corporate entity, and not a franchise model. And then, you know, JLL, which is corporate owned. Knight Frank, your parent is obviously listed company in the UK, but you're operating under license here, and you're a franchise of independent contractors, really, that are sharing information, but also running a network of small businesses. Now, one of the great benefits of that is that there is no question in my mind that the big four banks are moving towards brands in this sector. They're very resistant to having smaller boutique firms in this area. And I think what is driving a lot of that is consistency of data and presentation. And we can talk a little bit about where artificial intelligence is going. But one thing that it definitely needs for all of these new tools and automated valuation models and other aspects of the market that are going to come in, and maybe, I don't think they will threaten your existence, but you've got to be concerned about it. But what they will absolutely need is quality data sets. Otherwise, they just don't work. And the quality data set comes from you guys, and it comes from you guys doing your job properly. And that's why I think you're going to have a valued position in the market where you'll be using these tools to enhance what you do, but not replace what you do. But that's got to be something you've got to focus on. But what it does mean is that all the banks really are going to the brands. In the residential sector, you know, the time for boutique players is pretty much over, I reckon. The banks are making that pretty clear. But at the same time, we've got a huge growth in the non-mortgage sector. Sorry, the non-bank sector in the mortgages. So there's plenty of funds that are coming out to, you know, do second, third, and maybe even fourth tier lending, and they're going to be a much larger part of the market moving forward. And you've got to know how to deal with them. So so whilst what you do as a skill set between residential and commercial is different day to day, the principles are exactly the same. So I just want to emphasize that at the outset. All right, so let's get going. So I've got a little bit of a problem, right? So let's get going with the presentation. Now, just bear in mind that this is the API presentation. I didn't actually prepare it. But to get your certificates, I have adjusted a few things, but to get your certificates, you've got to go through it. So I'll actually skip through it and also enhance it where I think it needs to be enhanced. And just bear in mind that I do have a long-standing relationship with Knight Frank, and Neil Harvey and I work very closely in relation to your retainer agreements and your disclaimers. So I do know what the material you do look and feels like, and also where the risk areas are. All right, so the presentation is Practice Management Framework for Valuers and Valuation Firms. Now, they've updated a few guidelines recently. There is, and you'll get these, I've sent these slides through to Emily, but you do need to get onto the Valuation Management Quality Control, which is a new protocol that's put in place. I'll summarise it, but the API developed that in April 2025. And then, of course, you've got your rules of professional conduct. Now, they're just documents you've got to read and understand. You should click on a link. But just to summarise them, the online 2025 module includes an international guide that consolidates the requirements for the API rules of professional conduct and valuation protocol and provides valuers with a knowledge base to support their provision of valuation services to client. It's a guideline, and you should click on those links to read it. But let's just summarise the key points that are in it. The first one is identifying and understanding risk. Now, I'll skip through this pretty quickly. I'd be surprised if you guys weren't across this, because I do want to get into the case studies, which I think are more informative. But there are multiple definitions of risks, but they all share a central theme. That is the possibility of something bad occurring. And from a valuer's perspective, risk can be categorised as the potential for uncertain events resulting in a loss. Now, one thing I'd also expand on as a major risk is that your professional services just won't be in need in the future, and also that the biggest loss we're all concerned about is actually a cybersecurity breach rather than getting sued, because claims against valuers are almost next to nothing. So it's not just looking at loss in terms of being sued. It's the risk of having a data event, which means you could be put on the sidelines for a data breach event. I say that you could be put on the sidelines for quite a long period of time, but also the fact that if you don't keep evolving and developing and keeping an eye on the market, you could become completely irrelevant. So that involves identification, assessment and categorisation of the risks elements, and that's what we're attempting to do in this module. Now, for effective risk management, you've got to have systems, methods, practices to mitigate those risks, and that's why the API has developed that protocol. And the definition of valuation process risk is the possibility that the investigations or procedures followed by the valuer and or the valuation report is not fit for the purpose for which it was undertaken. Now, in terms of identifying and understanding risk, there are three distinct components. The first one is adequacy of investigations and procedures as part of the process, the suitability of the valuation report, and alignment with the purpose for which the valuation process was undertaken. And by breaking down the process in this way, the protocol provides a framework for identifying potential vulnerabilities at each stage of that process. Now, just turning at the pitfalls, technology and tools available to valuers have evolved, but the essential process remains consistent. And technology, including automation and AI, are tools that the valuer can choose to use or ignore as inputs, but these tools may create efficiencies or enhancements in the process rather than be seen as a replacement for the experience and expertise of the valuer. Now, has the environment in which valuers practice changed more significantly than the practice itself? Now, just in relation to this, while we're dealing with AI, if we were going to have a discussion about this, I suspect a lot of you would be using quite a few AI tools, and in particular using large language models, maybe to review your own reports or get summaries done of reports. These large language models probably would at the moment be seen as a much greater threat to the legal profession than they would to the valuation profession. But the position we're in at the moment is that our court system has evoked guidelines that make it professional misconduct for any lawyer to provide an AI-generated submission or court document that hasn't been reviewed and checked by a lawyer. And recently down here there was a King's Counsel who was referred to the disciplinary committee, providing submissions in an extremely difficult criminal matter involving mental impairment, a 16-year-old a girl who did some horrible things while suffering from a psychotic illness. And the law in that area, can get pretty complicated. But they provided submissions and referred to a number of cases that were obviously generated by AI, but the cases just didn't exist. The large language model just mashed them together. But we know those things will get better. But at the moment, they're just tools. And my view about this is that they will always be tools for us to use, and that we are going to, then it's not going to be a huge game changer. I'm a bit of a skeptic in that regard. It will definitely have an impact, but at the moment, it's just going to really be something to allow us to do better. But what it will do in professional services, I've got no doubt, is really lead to a big gap again between the bigger brands and the bigger companies and the smaller ones. And to give you an example of that, bigger law firms like the one I used to be at, which is DLA Piper, they have a internal data set that's proprietary and not available to anybody else. Just much like Knight Frank, would have an internal data set, assuming you do share data across your franchise entities. And that'll be a quality data set. It'll be collected by people who are talented. It'll be stuff that and can rely on, as opposed to the deep blue sea outside of your own data set, which could have any sort of crap, and not just crap that, from people who are really informed, but crap that's actually been mashed by bots and other characters that the bigger data providers are sending out there, so that the AI tools will deliberately be ineffective if they don't have access to a proprietary data source to make that proprietary data source more valuable. And I reckon where the bigger firms will get to is that and I know they're all training Copilot and tools like that to replace lawyers and produce absolutely ripping fact-specific letters of advice on highly complicated and specialised areas of law in a matter of minutes. So where I think that market's going to get to, and get there relatively quickly, is that a client might come to them with a brief and they'll say, right, we'll be able to give this to you in 5 minutes, but it's going to cost you 75 grand. Right? So because they'll have the Rolls-Royce quality proprietary data source and proprietary data source of opinions that they can readily tailor using AI, and they'll be able to do it with less people. So that's the way I think it's going in the law. I've got a keen interest in it in relation to the property profession, because I've invested in, and I'm chairman of a desktop assessment provider called Agrival, and we just focus on the agricultural sector. But where it's going to go and how good these tools are going to get pretty quickly is a really interesting issue. But the one thing it is going to need is the quality data set. And that's where I think the value is. And that's why I think, firms like HTW can actually go to private equity players and get them interested. And that's interesting, like all of a sudden, you're starting to get the investment market having a look at firms like yours and actually thinking there's something attractive about them. And if private equity is buying into one of your competitors, at 7 to 10 times earnings, then there's definitely something going on. And rather than be threatened by it, this is a period, I think, of real excitement for the valuation profession, because I can assure you, you wouldn't have attracted any interest from the private equity markets, at any time before now. All right, so just getting back to identifying and managing risk, and again, this is all about preserving quality. All right. And think about where you actually sit. You mightn't always be working for Knight Frank. You might be going elsewhere. But it's important to consider the practice management framework and risks that differ among various types of firms. Now, in large firms, do they necessitate stricter controls and separate quality managers due to their size? In my experience, almost certainly they do. Small and medium enterprises, what specific challenges characterise their risk profile? And for sole practitioners, how does their risk exposure differ from larger entities? Now, you guys probably sit sort of in the middle. You've definitely got quality managers that look after most of the risk issues that you need to be aware of. But because you are, smaller franchises, you've really got to understand the risks, understand the client profile, and understand how the risk they pose can be different. And in relation to employed valuers, you've just got to have an understanding of the entire profession, exactly what your business is about, so that you can identify these risks and understand them. And also, I mean, if you're an employed valuer, I guess if you just want a job and not a career, you can just focus on the little things and make sure you do your job fine, which is fine if that's the way you want to do. But if you actually do want a career, then understanding the whole value chain from client selection to product development, or even product development to client selection, to valuation process, to doing the work, getting paid, and then doing it again, is something you really need to know about. And for student members and trainee valuers, well, the particular risk factors that affect you are the ability to sit back and say, am I really being asked to do something that is right? And put your hand up when you think someone is overstepping the line. And I don't need to go into too many times, but I've had a lot of students ring me up over the years, ask me questions, and I say, no, that is wrong. And you need to call it out. Because, like it or not, there are still corrupt elements of the profession. I think everyone knows who they are, and it's only a matter of time before they end up doing something else. But, there are still people out there prepared to manipulate a figure for a fee, and that's just not something you want to be doing. Now, in terms of identifying and managing risk, the most important thing, and to a point really, the only thing that matters in my view, which is overstating it, is that the most important decision about risk and liability management comes with a retainer agreement. Now, this starts with the client selection of being proactive rather than reactive. So if you do get an instruction, you've got to work out, is this a client you actually want to do work for? Now, for the vast majority of people in the residential sector, you don't need to make that decision. It's already been made for you. You'll be on a bank panel, and congratulations, guys. There's, you've recently expanding that work significantly with ANZ. But there will be, lots of non-bank lenders that are going to come to you and want you to do their work. And if you get that request, well, there's plenty of ways to find out about a client. Work out what they're about, what's their own risk committee, where are they getting their money from. Someone really should understand what the client is actually doing, and don't just think because someone wants you to do work for them that you do work for them. You want to do work for quality clients. You want to do work for clients that are going to give you proper instructions. They understand what the process is, and they're going to pay you, and they're not just setting you up for some other big risk. And so the retainer agreement establishes the parameters of the engagement, and the risk reward element of that is essential. Now, in the slides don't say this, so just note the approach that Knight Frank takes, which I've worked out with the your business leaders over a period of time. The most important part of these retainer agreements is that we seek to limit liability to a contractual cap whenever we can. Right? Now, one thing that about half of the people in this room will think is impossible before I tell them otherwise, is that you can have an agreement that excludes liability for your negligent acts, right? So your screw-ups, right? Most people here would think, no, Dave, I can't sign a retainer agreement with my client that limits my liability if I make a mistake, right? Now, that is absolutely fundamentally wrong, right? You can exclude liability for your fuck-ups, all right? That's the way the market works. That is the way the law is. It's been that way for at least 50 years, right? There are three ways you get sued as a valuer. One is for breach of contract, right? Which only your client can sue you because they're the one that you have the contract with. Negligence, usually from this person who's read and relied on your report, or under the Australian Consumer Law, which used to be called the Trade Practices Act, for giving a report that is an expression of opinion, and if it's not a reasonable expression of opinion, the courts will find it to be misleading and deceptive, and find you liable for it. Now, what you can do is cap your liability for any of those causes of action at $1 if you want to, right? And, you know, people on this call have probably heard me tell this story a few times, but I'm going to get into two recent cases about it. But I was acting for a plant and machinery valuer who did a valuation for a new entry into the market who was going to do plant and machinery lending. And they were going to take out a CBA facility. He was a very experienced valuer, checked a portfolio valuation that had been done by one of the mid-tier accounting firms, made a few adjustments, did an absolutely fantastic report as to what the current value was and then what the orderly realisable value was on the sale of it. And for the plant and equipment that he was doing, which was a lot of mobile construction equipment, you know, cherry pickers and, you know, variable platforms and the like, said that this plant and equipment travels pretty well and it's universally used right around the world. So, you know, if there's isn't capacity in Australia, you can ship it overseas. And he did this global analysis of, you know, demand for this kind of equipment, and emphasised how orderly realisable value requires you to not only look at the local market, but look at the international market. So the valuation, the portfolio came in at 90 million. He provided that report, but before he did, he went to his client and said, "Look, I'm just consulting at the moment, you know, for a bit of fun." He was, you know, very senior, and he'd had held a lot of, you know, senior positions himself amongst, you know, asset financiers, as well as, you know, had many years' experience as a valuer. He said, "Look, I've had a look at the professional indemnity insurance market. I've got to pay like, you know, 80 grand for $1 million in cover. It's just not worth it. I'm not going to do this work if there is any risk of me being sued. So here are my limitation of liability clauses, which excluded any liability whatsoever." Sent it off to the client, well-resourced financier. They sent him an email back saying, "Yeah, we've had your terms and conditions reviewed," and they signed them. So he delivered them the report based on that. And relevantly, the terms and conditions had firstly, excluded any liability whatsoever. Secondly, had a cap on any liability, whether it be negligence, you know, breach of contract or liability under statute, being the Australian Consumer Law, capping that at a refund of the fee paid for the valuation, which was 42 grand, including GST, and also had an arbitration clause, right, which means that any disputes actually got to be resolved by a private arbitration. There's legislation that deals with how arbitrations are to occur, but to be resolved by private arbitration and not not a court. Now so the client then relied on it. There was no doubt that they relied on the valuation, and they then took out the existing facility. They advanced, I think, 55% or 60%. So the whole facility, I think, was about 45 million, something like that, to take out the other facility. And then within 3 months of them doing so, the borrowing entity got put into liquidation by the Australian Tax Office for not paying their statutory entitlements. Now, So he was in that very uncomfortable position where you've had a borrower fail, and so the orderly realisable value of the assets that he's just put $90 million on is going to be put under pressure. So he rang up the client and said, look, I've just heard about this. The client, of course, didn't contact him. He rang up the client and said, look, I've been in this situation before. Just don't panic. Don't think you can just put all these assets on the market to sell them. My report sets out how you look at the market nationally, and really you've got to look at stage sale of these. Otherwise, you'll dump all this stuff. People will get a bargain, and you won't get your money back. So they said, yeah, thanks very much for that. And he emphasised again, look, just don't go dumping it on the market. So after they dumped everything on the market and sold it all for 25 million bucks, they came and sued him in the Supreme Court, as well as all of the directors of the borrowing entity. Now they were suing, the financiers sued the directors of the borrowing entity for fraud, and then sued the valuer, for overstating. And they said, oh, how could he give an orderly realisable value at 90 million bucks? And we put them on the market and we've sold it for 25 million. And to even emphasise how right he was, there was another financier that took 15% of the same asset portfolio, and that financier sold exactly the same assets, albeit a smaller amount, on an orderly basis over time, shipping some overseas, and made a premium on the assessed value. So it was just a total screw up by the bank, but at the same time, I shouldn't really call them a bank. They weren't a bank, but you might be able to work out who they were. But really big fund. And so, but he is faced with a action against him personally in the Supreme Court of New South Wales for $20 million. He has no insurance and he's got all of his assets in his name. And so it's fair to say that he was under some pressure at the time he came down to see me. So and so I said to him, well, show me your retainer agreement. I had a look at the retainer agreement. I said, well, there's a limitation of liability clause in here. It really should work, but there's also an arbitration clause. What we do is the arbitration clause will hold. We apply to the Supreme Court of New South Wales. We'll get that proceeding stayed so that the matter can go over to arbitration. And then at arbitration, we'll ask the arbitrator to assume every allegation that is made against him is correct, right? So to assume a fuck up, assume that he has totally got the valuation wrong, that he should have put an orderly realisable value of $25 million on this portfolio of assets rather than the 90 million that he actually did, right? So ask the arbitrator, assume all that, assume everything they say about him is correct. Can the claim proceed because of this cap on liability? And we put it up to the arbitrator, and the arbitrator said no, it can't. All of those three claims are caught within the cap. There is absolutely no reason whatsoever why this claim should proceed, right? And so it was struck out and went away. So this was a person who at one point was looking at all of his hard-earned assets over his entire career evaporating overnight. Because of one client, but because he'd paid attention to the scope and purpose of the retainer and put in a liability clause, he not only got out of it for nothing, every cent in legal fees that he paid was paid by the client. So that is the importance of retainer agreements, right? They really work, right? And they are there to eliminate your exposure to shitty client behaviour. That's why they're there, right? And so at head office, or it's not really head office, but Knight Frank Australia, Harves, Nick Bell, Jason Oster and, others over the years, we've worked really hard to make sure that the engagement letters really protect you as best they can and protect you for that reason, right? So considerations for you when you're negotiating agreements: is the engagement desirable? Is the client necessary to the long-term sustainability of the valuation firm? Can a valuer properly undertake the valuation service in a professional, competent manner? And can time requirements be met? But the one thing that's sort of left out of all the API material is what is the cap, right? Now, for banks, the cap is the cap liability scheme, right? Which is a legislative requirements. And then in relation to non-bank lender, generally we try and cap everything at 10 times fee. Right, so the most you're ever going to be exposed to, is 10, 20, 30, 40 grand. And because what we're just doing is just taking off the table these sorts of arguments, right? And the main reason we're doing that is you guys don't have enough margin in your business structure to take on that risk, all right? Okay, so now a couple of other things when you get into retainer agreements, and I'm starting to see this coming back. I don't know what the AI is picking up for these non-bank lenders and others, but they're starting to say that your agreement is to provide an accurate valuation. Conceptually impossible. It's an expression of opinion. Agreements to perform services at best or highest industry practice or highest professional standards. And whilst that might sound perfectly reasonable, no, your legal obligation is to exercise reasonable care and nothing more. If you assume a higher duty, then it's just going to make life much difficult for you. And then not only would you, they're trying to write out these liability caps, they're also trying to put in indemnities and warranties that make it very easy to recover a loss from you. Also trying to put in unreasonable completion timeframes. So you've really, or ask you to make assumptions that are just improper, unachievable or inappropriate. So you've got the good fortune at Knight Frank to have a pretty sophisticated, access to quality advice and systems. Stay within them. Right, they're there for very good reason, and I would hope that you can remember the story about my plant machinery value as to how important this actually is. I won't get too much into these other onerous terms, but you've got to be careful not to accept responsibility for third-party information or opinions. So if there is an asbestos report, make it clear that you're relying on that and you're not going to be responsible if that opinion's wrong. If additional expertise is required, say it. Look at appropriate qualifications and disclaimers, and I'm going to talk about that a bit later in relation to this case involving CBRE from a couple of years ago. And, seek advice regarding, your IP rights and confidentiality provisions, because this data and confidentiality is going to be a very big piece for the next decade. And, read up, understand it, work out where it's all coming from, and obviously work out your client's needs. Now I'll skip through the next one. I hope I've made it clear that careful client selection is critical, and effective communication is what you are all about as professional people. Getting in relation to the extraction change, look, I think this is all pretty straightforward. Everything's got to be documented. If there are changes in your instructions, you've got to work out whether you want to accept them or decline the retainer at that time. And you've obviously got to do everything you're required as a professional, like all the necessary investigations and inspections to be conducted, applying professional judgment and professional skepticism to ensure sufficient and adequate information is obtained to inform your opinion. Now, to emphasise that a little bit further, there is a case that's referred to in the material. And look, it concerns Arcus shop fitters, but it was a case where they were getting expert evidence from various valuers, and what it had was that there was three bits of valuation evidence when they'd identified a range of comparable sales evidence from about $300 a square metre up to about $1,300 a square metre. And the judge just looked at it all and said, look, I can't really tell why you've struck on your assessed values. I think one was at 440, one was at 800, and one was at 770. He said, you're just not explaining to me what it is or how you've actually analysed the evidence. Now, so just bear with me for a moment, because I'll just get I'll just move into the screen that hopefully you can see the decision. So, Nick, can you actually see that? Is that font large enough? Or can anyone tell me where you can actually see it?
Yeah.
If you could just maybe zoom in just a little bit would be great.
I knew you'd say that, and I don't think this is a good one. I can on a Word version of it, right?
We can deal with that, Dave. That's fine.
Yeah,
Yeah,
sure.
we
All
can.
right.
I can read it.
Yeah, that's right. Now um, all right. So look, it's worth. I mean, you can go into AI. I won't spend too long into this because it was actually um, a pretty long analysis, right? But if you're in a situation where you are giving expert evidence, and I would certainly encourage you all at some stage of your life to actually do this because it is the ultimate test of your performance as a professional, and it gets you to really focus on how you clearly communicate the opinion you're providing. And valuers that can do this work usually shine above the valuers who don't. And often because you've got a real challenge in your profession. You've got to be extremely good in relation to the numbers and the analysis, but then you've also got to be able to articulate how you've arrived at something. And often people who are very good at numbers and analysis just assume that everyone's on the same board and they can get why, if I've analysed this range, you can work out why I've landed on 700 a square metre given this range of evidence. But that's not the case at all. Most people out there, and certainly judges, are terrible. They're not naturally good with numbers, and they need to have these things explained to them in very basic terms. Now, so it's worth having a little bit of a read if you've got some spare time. But this is the kind of things that the judges go through. They will, summarise cases like this to say, right, it is general valuation practice for sales characterised as comparable sales to be used as bases for the valuation of land said to be similar, but allowances must also always be made before such sale can be so used, right? And one thing you'll realise when you're going through these judgments is, Jesus Christ, like I learnt that on my first day at uni. I've really, got to explain these things when I'm giving evidence, and the reality is you do. And it's that ability to go back to the fundamentals and then explain yourself within that framework that's very clear. So judges, have got to explain to people, what direct comparison actually is, whereas, that is your absolute bread and butter. So don't just assume that people get it. And then they'll go through and then analyse the methodology. But when you go through the way the judge approached it in this case, is that the judge just said, look, I've got 3 valuation reports in front of me. I don't know how any of these people landed at the opinion they did, right? And was really very critical of that. So I think that's worth having a look at. The actual quote that case refers to, which is really one that's quoted a lot, is a case called Makita Australia v Sprouse. Now, that Makita Australia didn't concern a valuation. That was engineering expert evidence. But the shining light is the correct principle is, in my view, that the valuer must reveal as far as is possible the process of reasoning actually employed so as to enable the court to evaluate the evidence and the expert's conclusion. Right, so it's got to be something that that is transparent. All right, I'll skip through this. Got to have good records. Make sure that you keep a record of what you do. Self-review checklist, documentation standards, periodic peer review, client feedback, regular review of processes, all needed. I know you guys do all that at Knight Frank, so I'm not going to waste your time going through all that, but I will go through to what I think is a pretty interesting case called President Shabatoni. Now, just interested if anyone on the call is actually does family law work. Nick, I'm assuming there's a reasonable number who do.
There's a few that would come across family law, yeah, but very much the minority.
Right. Okay. All right. Well, look, I'll just go through because I will move this across. Right. So this is just the decision in Perez. Now, family law, and this was actually an estate planning case, but it was a dispute between It was a dispute between brother and sister. And look, again, I think kind of kind of an interesting case. I When I was reading it before, I actually read this, and I don't know, other people are in my circumstance, but I've got a 21-year-old, a 20-year-old, and a 16-year-old at home, and one of them's just about to take off overseas for 6 months. And it gets to, well, when your child is starting to become an adult. And what these estate cases are all about usually is that mum or dad, or usually the last surviving parent, has passed away, and then the siblings are left there. Often the case that one sibling has done better than the other, and this was another one. Perez, for whatever reason, had not performed particularly well in life, was in dire financial position, had actually been living upstairs in the house in Coogee, and the mum left about 350 grand to all of the grandchildren, and then half of the estate to the daughter and to the son, but also said that the daughter has been living rent-free in the Coogee home for the last 20 years, and there's got to be some adjustment for that, and she married a dickhead, and my son married someone really nice, so she made the son the executor, and he had the responsibility of trying to sell the house, but the plaintiff refused to move out. And so the valuation of what the house was worth was actually a very important piece of evidence in relation to resolving this dispute. So I think that's the first thing. If you are doing this work, your opinion really matters. So don't be influenced, just do a proper job. And one thing that you will get out of Perez, and also out of the previous case I referred to, is that the judges actually expect you to act in a judicial capacity, right? Oh, just act in a way where you really do, analyse the evidence and you reason it properly, right? And so that takes a lot of effort. So if you are doing this work, just make sure everyone knows that the fee you're going to be charging is 10 times what you would be doing for a bank, to value the same thing, because all of these people are often very distressed, as they are in estate matters and in family law matters, and they need all of these things explained, right? But I just thought this quote was good. The relationship, this is the principle that governs these estate cases. If you guys ever get interested in it, which usually everyone at some point in their lives does. But in relation to this claim, the plaintiff's claim being a claim by an adult child, the following principles are useful to remember. The relationship between parent and child changes when the child attains adulthood. However, a child does not cease to be a natural recipient of parental ties, affection or support as the bonds of childhood are relaxed. It is impossible to describe in terms of universal application the moral obligation or community expectation of a parent in respect of an adult child. It can be said that ordinarily the community expects parents to raise and educate their children to the very best of their ability while they remain children, probably to assist them with a tertiary education where that is feasible, where funds allow, to provide them with a start in life, such as a deposit on a home, although it might well take a different form. Generally, also, the community does not expect a parent to look after his or her child for the rest of the child's life and into retirement, especially when there is someone else, such as a spouse, who has a primary obligation to do so. Plainly, if an adult child remains a dependent of a parent, the community usually expects the parent to make provision to fulfil that ongoing dependency after death. But where a child, even an adult child, falls on hard times and where there are assets available, then the community may expect a parent to provide a buffer against contingencies, and where a child has been unable to accumulate superannuation or make other provision for their retirement, something to assist in retirement where otherwise they would be left destitute. So if you're getting into family disputes about all that, and you're wondering why your parents have got to make provision for your let's just say less performing siblings, that's the guiding principle in this area of law in Australia. Then it becomes of fundamental importance in these cases to determine the true value of the estate. And the significant difficulty facing a court on this application is that the asset in the estate is not being sold, and nor is it ready for sale, but they've got to strike a valuation. Now, what then happened was the parties had done some short form short form appraisals by, your local estate agents, 3.6 to 3.9. There'd also been some other appraisals and desktops in various ranges, but unsurprisingly, the defendant got a proper valuation report prepared by Kirsty Kurswell of Waterhouse Valuations dated the 5th of February. She was a registered value. Her opinion was of 4.15 million, and look, entirely unsurprisingly, but as you would expect, I just scrolled down. The court greatly preferred her opinion. And said her report, which is cogent and well-reasoned, is based on her inspection of the property on 5 February 2024. Her opinion is that the property in its current state has a value of 4.15 million, but that the property is currently in a below-average condition and that the value would be higher if the property was renovated. The evidence therefore suggests a potential range of values from about 3.6 up to 539. However, for the purposes of assessing the plaintiff's claim, I need to form some view as to the value of the estate. In doing so, I give far more weight to the Waterhouse valuation than to any of the other valuation evidence. It is cogent, reasoned, expressed by a registered valuer, and is based on a contemporaneous and thorough inspection of the property. It is also the most closely dated to the time of the final hearing, and so the judge accepted the valuer's opinion. So, done right. You're a great assistance to the judiciary. Now, I just want to get into the next case because we're coming up on time, and this is a Victorian case called Patent Securities. Right now, I'll let you have a look at all the slides, but all you need to know is that Bataco Ferrier got retained by Patent Capital Proprietary Limited. Now, you will notice here that the plaintiff is described as Patent Securities Proprietary Limited, but it was Patent Capital Proprietary Limited that retained the valuation firm. Now, Bataco's did 4 or 5 valuations of the same development property, and that development property was subject and the loan was subject to the valuation, but also to evidence of pre-sales. Now, one significant piece of evidence was that an estate agency firm had just made up a range of pre-sales, and there was this great piece of evidence in the case, an email between the estate agent to someone else saying, "Oh no, we just made up those pre-sales with all the Chinese buyers because that's what you thought you wanted us to do." So the pre-sales were completely doctored, and were a condition of the loan that there was 75% pre-sales. So there wasn't too much of a difficulty in Patent Securities having some recovery. But in relation to the claim against the valuer, that claim failed. Now, the reason it failed was because there's lots of reasons. I mean, they did actually make out errors with the valuation report, but the judge was pretty clear in a very long judgment that it had nothing to do with the loss that was suffered. But most importantly, the judge simply said this: the only duty of care and the only representation was made to Patent Capital Proprietary Limited. Now, Patent Securities obviously was given that report. It was the one that then got together the funding for the loan, but Patent Securities never had a valuation report addressed to it. They're not allowed to rely on the report. End of story, right? So the third-party disclaimer in that case was 100% effective in avoiding the claim, because there was no contractual relationship between Patent Securities and Bataco Ferrier, and there was no duty of care owed between Patent Securities and Bataco Ferrier. Now, so when we talk about properly identifying your client and making sure that there is a third-party disclaimer, that's why. It's so that you control and that you're 100% certain over who your client is. And this decision really confirms, what I've been saying for a number of years. At least a Victorian judge has found that. And look, have a look over the slides. The slides do accurately summarise the case, and it's very, very important for you to be 100% clear at all times as to who the reliant party is going to be, because that's the only one that you're extending professional responsibility to. But there is a case up in New South Wales that was decided in the same year. Now, the valuer won this case, right? A lot of you would probably know the name Chris Nicodemu. He was working at CBRE at the time, but this was a decision in 2022 that related to a valuation done by CBRE Victoria in 2007. And it concerned a very controversial, but now very lovely development, but very controversial development called Martha Cove, which is down on the Mornington Peninsula, just south of Frankston. Now, there was a 2007 valuation done by CBRE. City Pacific raised a lot of money and then went into liquidation at the time of the financial crisis, and the liquidator then took a long time before it commenced this action, actually commencing it in 2015. Now, interestingly, the case actually failed because the Court of Appeal held that it was statute barred, in that the claim should have been brought within 6 years of making the decision to acquire the property in 2008. But then the court went on to consider, well, could the valuer be liable in a circumstance where the valuation was addressed by CBRE to the owner of the property, right? But City Pacific at the time was a mortgagee who'd advanced money against the property, but then they made a decision to enter into an option to purchase the property. I know it sounds bizarre, but it was. You can understand when you look at this deal how it is that City Pacific went into liquidation. They just weren't following proper process at any stage of it. But they entered into an $11.2 million option fee to acquire the property from the owner, and then they went into liquidation and they defaulted and they lost their money. And so they sued CBRE for the option fee, saying that the valuation that they read or relied on, even though it wasn't addressed to them, was the reason that they'd entered into the transaction. Now, for tactical reasons, CBRE's lawyers conceded that the valuation was not a reasonable expression of opinion and was therefore misleading and deceptive conduct under, at the time, Section 52 of the Trade Practices Act, which there's exactly the same provision is now called Section 18 of the Australian Consumer Law. But one argument that went up before the Court of Appeal was that the third-party disclaimer, which says that the report is only for the named party, which, to stress it again, was not City Pacific. This report was not named to them. It was well known that they were involved in the transaction, but the report was not named to them, as to whether or not that disclaimer itself just chopped off any cause of action at the knees. Now, as I think I mentioned before, there are three causes of action that you get sued as. One is for breach of contract for not providing a reasonable opinion. Second is a common law, as in negligence, for not providing a reasonable opinion. And the third one is under the Australian Consumer Law for not providing a reasonable opinion. So it's three causes of action, really making almost exactly the same allegation, but for various reasons, the law always treats them as separate and distinct. And so City Pacific conceded that there was no contract between the valuer and City Pacific. They also conceded, but they tried to argue that in this circumstance, CBRE knew that City Pacific was going to be relying on the report, and so therefore they owed a duty of care and that a representation was made to them. Now, unlike the decision of the judge in Payton Securities, the New South Wales Court of Appeal said that the disclaimer itself, or the fact that there was a third-party disclaimer in the report that limited the scope to only the named addressee, did not, and this is the quote from the judgment, immunise, right, CBRE from liability. But what they did say, that from an analysis of the facts, the valuation was not the cause of the loss. So this creates this little wedge in the law where, some clients can say, oh, look, even though the report's not addressed to me and there is a third-party disclaimer, it was well known that I was so intimately involved in the transaction that, I'm allowed to rely on a report or I can be misled even though the report's not addressed to me. And whilst in theory that argument is left open by this case, it is still, I'm still not aware of any decision in the last 40 years, or the last 30 odd years, where a valuer who has been found liable for that since third-party disclaimers became a feature of the market, which they did based on advice from firms like the ones I was acting for, became a feature of the market in the 1990s. And what the court held was that this couldn't possibly be the cause of the loss. And it's really another way of stating the same issue, that if you are reading and relying on a report that's not addressed to you, how can you be misled, right? How can that be the cause of your loss? And in this case, the judge said there was all these other considerations, and if you want to read the case, you'll see that there's a few internal memos where actually a fairly experienced lender looked at it and said, oh, look at all of these assumptions that Chris has made in his report. I can't verify any of these assumptions. I don't know if they're going to become true, and these things have got to be looked at before we make a decision to purchase. So in this situation where you have someone reading and relying on a report that's not addressed to them, it's still very hard to imagine how it could be said that that valuer could be legally liable. So the valuer won this case, but it's a very clear message. When you are having borrower-instructed valuations, where you are preparing reports that are going to be relied on by a lender, but you don't know who that lender is, it remains a high risk area, and the how you enter into that transaction and how you prepare and express your report needs to be very tightly controlled. And Harves and I do a lot of work in relation to that to make sure it is, but that's where the claims are going to come from. So thanks for attending this session. I will now open up to any questions, if anyone's got any.
Emily, I might hand over to you. Is there any that have come in on email or in the Teams chat or anything?
Unfortunately not, sorry.
No worries. Open it up. If you've got a question, please feel free to ask. I've just got a couple of things just for clarification.
Sure.
Dave, that last point around reliance. So I guess that an instance might be if you're asked by a mortgage broker to do a valuation and you did it, it's reasonable to expect it's going to be used for mortgage purposes, even though you haven't addressed it to a lender. We need to just treat, I guess the key takeaway is if it's for discussion with a major lender or a discussion for mortgage purposes or anything along those lines, just prepare it as if it were instructed by a major bank and with a cap liability, because some of the problems that we get are because, when I say problems, it's more the property risk people get these reports, and even though we've said this isn't for anyone else's use, it still lands on their desk, and then they get a bit annoyed because it doesn't come, it's all subject to these conditions. Well, we would never release it to that bank with those conditions. And if we do, we'd have to put them clearly up front. So I guess just assume that anything that's borrower instructed is going to land on your most annoying property risk person's desk, and then you've got an out if it goes around the back door and they don't come back to you first. That's probably the first thing I'd say. And the second part, Dave, was around cap liability. Is an interesting one, and I know probably the residential teams don't tend to do as much of it because that market is what it is, but the non-bank lenders in commercial, we've always said greater than the fee, 10 times the fee, or $100,000, the greater of. Based on what you've said with that case, should we? Because it was always aligned to what's reasonable for the extent of the loss. Is that something we could look at changing and saying, the lower of 10 times the fee or 100,000, or any tweaks to that, given that your comments, the $1?
Yeah, no, look, we've drafted all these retainers with that case in mind. Really is a matter of as a matter of law, whether it's $1 or 100 grand, doesn't actually matter. It's more being able to just sell it commercially. And the rationale is, enough to hurt, not enough to kill. So, 100 grand's still a big chunk out of your business. It'll be about the amount of an excess you'll have to pay in relation to a claim, and that's enough to make sure that you're going to do a proper job. So it's still an important part, and I totally agree with what you're saying, Nick. I mean, if you are doing borrower instructed valuations, even the biggest idiot risk officer needs to know that the report in front of them is not for them. Right. And even though they say, oh, look, you were going to give me a report just addressed to me that said exactly the same thing. We said, no, mate, that's just not the way this works. You have a report addressed to you, or you don't fucking lend. Right.
Yeah.
And if you think you can do anything out that, you will just be laughed out of the industry. I mean, seriously, what competent financier could ever think that they can rely on a report that's not actually addressed to them? There just shouldn't be one. So and so you've just got to assume that your report doesn't give them the license to think that they can do that. And look, I've got one case where I've got to step in and explain this to a pretty respected financier actually, but they know it's a screw up. Like what financier has set up a process that they can rely on valuation reports not addressed to them? Like, it's just, there's no competent process in this market where that happens.
And another thing that just came up today, so it's quite fresh. Would you just be able to explain for non-bank lenders, and this happens in the residential and the commercial space, the difference between the contributory mortgage fund? So if you're looking at the risk profile of a lender, and we put cap liability in for non-bank lenders, but some that might be a pooled mortgage fund and some that might be a contributory mortgage fund, what's the risk profile of each of those and how?
That's a good question. With a contributory mortgage fund, your risk profile is the number of contributors, because contributory mortgage funds, generally, they are named as security holders on the title search, right? So as the basic contributory fund is, me, Nick and Jason go into a contributory mortgage. We each put in $500,000 on a $1.5 million loan, and we're named as the three contributors, and a report addressed to that, that fund is actually being addressed to all three of us. A pooled fund, the only named recipient of that report is the trustee, and none of the recipients. And it's just that transaction is being held by one single entity that has responsibility for all of the beneficiaries. And the difference is that in a pooled fund model, you've got one client, and in a contributory model, you've got 3, 4, however many you put money in. And obviously you want the one client, not the dozens, because how do you go through know your client rule? You'd have to do due diligence on all of them. Now, you might be able to do that. But it's just a much more complicated, much more unsophisticated, much more cavalier end of the market.
Yeah, and presumably under the contributory mortgage fund, you'd have to get a sign off from someone that's either get all the parties involved or someone that's authorised to sign off on behalf of all the contributors. Would that be right?
That's exactly right. And so the messier the finance structure, the higher the risk.
Yeah.
And not just slightly higher, like massively higher. And so that's why. And look, like every time there's a new client, I mean, I get asked the question. And look, recently, we're doing a PVA panel value agreement for a new mob. I forget the name of it, but I had their, I got put in touch with their risk officers so that we could work out exactly how many funds they had, who the trustees were, whether they were contributory, whether they were pooled, or whether they were pooled or managed, right? So they've actually got a pot. Pooled tends to be, we've got this deal and they package it up and their unit holders elect to invest in it. And managed is, they make the investment at their discretion. And, of those, managed is lower risk, pooled is, higher risk, and contributory is higher risk again. But we get a full, diagram, who's on the risk committee, but how many funds they've got, how many Australian financial services licenses they've got, what's the scope of that license, where are they raising their capital from, and what's their process for reviewing valuations and approving loans. And, that's the level of due diligence I think you've got to do on these ones, because a lot of it's foreign money. Uh, you know, it could be, corrupt governments expatriating money this way into safe haven like Australia, or it just could be a pack of idiots who are just out there to, lose money. Um,
Yeah.
and you can tell pretty quickly whether they're taking it seriously or not. And look, and the vast majority of them are, don't get me wrong, there's good money to be made in Australia in this market by doing things properly. So there's no reason to manipulate it. But I just see us going back 30 or 40 years in relation to where the market was, sort of late 80s, early 90s, and there are some real similarities.
Yeah. So the questionnaire, most of you would be aware of it. The questionnaire that for lenders that Neil's put together, they basically fill it out and answers all those questions that Dave's just raised around where you get your money from, what sort of licenses and how you're governed, and that gives us. Then we basically make an executive decision on, are we comfortable to do work for these guys or not? What's the volume like and those sort of things. So there is a bit of a process when we take on new residential or commercial lenders. It's just knowing as much as we can before we dive in. My last point, more so than a question, Dave, is we're pushing. It's part of a transition over the last few years, is trying to ensure that no one's doing evaluation for internal decision making purposes. I'm sure that's come up with you and Shuey in your discussions, but a lot of the times we get asked, we're just doing it for internal decision making. And what we understand is in the past that has led people to be doing buyouts and all sorts of things, and they just call it that. And then you find your valuations going to 6 different shareholders to decide what the property is going to settle for. Have you got any comments around that?
Yeah, I mean, it's just that no one knew what that meant. Like internal decision-making purposes. Look, generally where we've landed, for internal financial reporting purposes, but also just, having a discussion with your client, exactly what are you going to use it for? And look, the case was, I mean, it didn't end up going anywhere, but, Shuey was asked to do valuation reports. This was, of a portfolio of assets, and this was 20 plus years ago. And it ended up that they used his valuations to resolve a shareholder dispute, to divvy up the assets, much like the estate planning dispute that I've just told you about. Now, in that one, the valuer well knew what their valuation report was being used for, but when you get, vague, I just use it for internal reporting purposes, they could conclude that they can use it for anything, including, this portfolio has been valued at 200 million. We'll use that as the basis to, pay out this shareholder 40 million bucks. And then that shareholder says, oh shit, you undervalued it, I should have been paid 60, and then you find yourself on the subject of a writ for 20 million bucks. Now, that's not what happened. But it's about when they say, oh, we're just going to use it for internal reporting purposes, you're effectively saying, right, well, I'm just giving this to you for information purposes only. You are not to make any commercial decision at all.
Yeah.
Based on that, until you tell me what that is.
Yeah. Ask more questions until often you get to the actual baseline, and sometimes it's a misunderstanding from their point of view, or you just say, look, we can do it for financial reporting purposes in accordance with accounting standards and complete it that way, or effectively the truth might come out if they were trying to lead you down a path. But I think getting that part right at the start and asking lots of questions will limit our exposure there.
Yeah, look, yeah, absolutely. And again, it's just I'm just seeing more and more of that sort of behaviour happening, and so just having your risk radar up about it. But it's a feature of your market that often your reports are read by 20 different people. They pass through a hell of a lot of hands, and but who is making a commercial decision based on the opinion you're giving, and is my report suitable for that purpose? And if it is, then go ahead. But, if you're uncertain about that, then don't be. Just ask a few more questions until you are.
Okay.
I got a
Thanks,
question
David.
on
Questions?
I got
sure.
a question on cap liability in
Yep.
relation to financial reporting valuations. I know you've talked on it before. Maybe just able to explain why that's fallen out of the financial reporting instruction letters.
It's because there's never been a claim against any valuer in Australia over financial reporting purposes. And the main reason for that is that it's only used for preparing your end-of-year accounts, and no one relies on those end-of-year accounts to make commercial decisions.
Yeah, and then to add on to that, so where does financial reporting, that purpose, end, and where does another sort of, I guess, purpose start? And it links into what Belly said before, into internal decision making, something like that. Like, because sometimes you find that you do a report for financial reporting purposes, and halfway through the engagement, like I know it's happened to me, it turns into they're actually looking at disposing of some of the asset to another business partner or something like that as well. Where does that, I guess, like land? Like, where's that line? I guess, what is financial reporting and what isn't? Where does it go to the next purpose?
Well, financial reporting is just when your opinion is going to be used for one purpose, and that's to plug a particular element into their financial accounts, right? Which will be one of, I don't know, usually 1,000 separate inputs, depending on how sophisticated the organisation is. Other than that, if you're only talking about either a mortgage, sale or acquisition, right, in relation to property, and you say this is for financial reporting, it's not to be used for any sale, acquisition or mortgagee purposes.
Yeah.
So Cam, if that does happen, I guess once you know that it's not for financial reporting, then you need to get another engagement letter and actually do it for the purpose that they are now telling you. Because once you know it, you can't unknow it.
Yeah,
that's very true, and that's right. And you can go through and you can do that, and once you know you're into a riskier area, that's fine. You can manage it, But the real problems come when you're doing something and the scope and the purpose is misaligned with your client. That's just the biggest risk. If you're 24/7 clear as to exactly what you're doing for that client, you never have a problem, and you provide a better professional service as well. But absolutely, they start off, oh, we want it for financial reporting purposes, and they say, oh shit, we're actually thinking of putting this on the market. Or we've got someone who's just come out of the woodwork and they want to pay us, 250 million for this portfolio. We've had a look at your value. We've had a look at your financial reporting purposes. We think that's the right price. And you're like, that report was prepared under the accounting standards. That's not market value on normal concepts, right? They might align, but they might not. Don't you want me to look at that, properly? And if you want an opinion from me as to, what I think it's going to realise if you put it out to market, or that if this is a good deal, fine, I'll give you that opinion. But that's not the opinion I've given you thus far. So it's just operating commercially.
Yeah. Thanks, David.
Conscious of time, but is there any other questions you might want to throw while we've got David one-on-one? There's no silly questions. Well, there are, but
no worries, guys.
Are we still using that hold harmless 2-page letter in front of the I guess limited, where we want limited liability, or is that not used not anymore?
No, absolutely. It's being hopefully it's being used. I mean, I drafted it. So there are there's precedents for family law, borrower instructed valuations, are the main ones, and then standard terms and conditions that start from the position of a cap liability. And we're also starting to work up panel value agreements for specific non-bank lenders that are giving you work on a regular basis. And in all of them, we're just getting working to get 100% clarity on scope and purpose. But absolutely, I mean, these non-bank lenders need you more than you need them. Now they are going to become a profitable section of the market. There's no question. Everyone will be doing work for them, but the smart money within those organisations know that they want you at your best, right? They know that, and you're only educating them by saying, well, we're going to give you a proper job, but we're not going to be exposing ourselves to the downside of your business. And and they expect you to ask them for it.
Yeah. Dave, just a quick point. So we're sort of about to re-release a report generation tool within Orion. It's our platform. There's some comments around the group where we just need some alterations to some reports and for various clients, DHA, et cetera, I guess the point you've just raised there is if you're going to be crafting a report output for a client, you want to have the retainer drafted probably at this before that, rather than at the other end. So if you're thinking about designing a report for a client, you want to get the retainer right.
Yeah, absolutely. Yeah, absolutely. And look, designing an end-to-end process that integrates, Jason, I know that, the tech is your thing, and the better you do that, so that the retainer, goes into your valuation report as well. That's where the money's to be made.
Yeah.
Yeah.
Cool.
Great. All right. Well, if there's any other questions, perhaps we'll still submit them and we'll find answers from Dave another time. But David, on behalf of all of us, thanks for putting that presentation together. We really appreciate it. And no doubt we will see you again to do the same thing next year.
Good on you guys. Thanks very much.
Okay.
Really value the
Thank you.
relationship. See you later, fellas.
Good on you.
Thanks, David.
See ya. Bye.
Some people learn to use it.